NACDL is the association of the nation's criminal defense bar.
I'm going to talk to you about legal fees, specifically what you have to do to keep the government from seizing the assets that you need to be able to fight the government either at trial or at sentencing. I don't have to tell you how expensive it is to run a practice today. First of all, you have to be able to pay your rent, not to mention your mortgage and your automobile costs and the cost of college and even the cost of going to Disneyland. I don't know if you've been there recently, but that can cost a fortune. So you have to be able to deal with the government, which is bent on preventing you from having the assets necessary to render effective assistance of counsel. Now, the government has a number of statutes in its arsenal. And I want to just set the landscape by going over some of these statutes with you. The leading statute is 21 U.S.C. 853. And that statute subjects to forfeiture where a person has been convicted of a drug offense and the property in question constitutes or derives from any proceeds the person obtained directly or indirectly as a result of such violation. It is very broad. And it is very easy for the government to go to a magistrate and get an order to freeze someone's bank account, restrain the use of their business, and effectively shut down the opportunity of your client to hire you or hire anyone that he would want to represent him or her other than court-appointed counsel. There's also another feature of 853 which is very treacherous. It has to do with substitute assets. And we'll get into the issue of whether or not the government can seize substitute assets pre-trial. But you should know that it gives the government the opportunity to seize untainted assets up to the amount that cannot be located upon the exercise of due diligence, has been transferred or sold to or deposited with a third party, has been placed beyond the jurisdiction of the court, has been substantially diminished in value, or has been commingled with other property which cannot be divided without difficulty. The government also has the authority to get warrantless seizures. So they can go into a bank and convince a banker to freeze someone's account even before they get authority from a court and even before there has been any indictment. And when there is an indictment, their authority is very broad. 21 U.S.C. 853E enables a court to enter a restraining order or injunction or take any other action to preserve the availability of property upon the filing of an indictment or information charging violation. Now, what this means is that the court can issue a protective order that's filed in the same docket as your case, and which tells anyone in the world that specific property belonging to your client is subject to forfeiture and cannot be taken under any circumstances short of getting permission of the court. Two cases have come out in the last couple of years where the Supreme Court has dealt with issues having to do with restraint of property needed for attorney's fees. One is Kaley versus United States, and the other is Lewis versus United States. What happened in Kaley is that the defense counsel wanted to challenge the probable cause that the government relied upon from the indictment to restrain assets which the defense contended were absolutely essential for the defense to have counsel of choice. But the assets in question were, under the grand jury's indictment, tainted assets. And the question was whether or not the Sixth Amendment guarantees a right to access to property where the grand jury has already determined that there was probable cause to believe that the property was tainted. The Supreme Court said, sorry, there is no difference between probable cause needed to restrain an individual by way of an arrest or pretrial detention, and probable cause needed to restrain one's property. So if you can do one, if you can rely upon the grand jury to hold someone in custody from the time of their indictment all the way through the time of their trial and thereafter, then certainly the grand jury's determination of probable cause is sufficient to justify the seizure of assets. But the question that was left open by the Supreme Court in Kaley was whether or not you could seek a hearing before the court to try to show that a particular asset that the government had frozen was not tainted. And there, this is the Lewis case, the Supreme Court rejected the government's arguments that they could restrain untainted assets. And the court gave defense counsel an opportunity to do what a lot of us had been doing since Monsanto and Kaplan versus Kaplan and Drysdale, which was to go before the courts and attempt to establish that particular assets which were frozen were actually not tainted by any criminal activity. And essentially what the Supreme Court did was it said that this is an appropriate method of ensuring the defendant's right to his Sixth Amendment right to counsel of his choice. In distinguishing Kaley, the Supreme Court in Lewis went back to the old argument that's always made by the government, which is a bank robber cannot take the fruits of his labor and go and spend it on an automobile and the money be suddenly untainted as a result of the bank robber's actions. The bank robber's possession of the money does not change the fact that it still belongs to the bank. But in Lewis, the Supreme Court said, well, that's not the case. When you have untainted property, it's not property that's used to facilitate a crime. It's not property that is the proceeds of a crime. It's not property that somehow was used in the commission of the crime. It's my property, and I'm entitled to my own property. What's mine is mine. What's yours is yours. And so the court gave us new authority, or rather put its stamp of approval on the authority which we have used in order to release property that had previously been restrained. Okay, let's deal with substitute assets. Substitute assets are assets that are untainted, but which the government seeks to seize if it cannot satisfy its forfeiture judgment up to the amount that it was seeking to forfeit. There was a question whether the government could seek the restraint pre-trial of substitute assets. And every circuit that addressed the issue but the Fourth Circuit had held that you could not restrain substitute assets. But the Fourth Circuit went its own direction, and if you were unfortunately in that circuit, you could have your innocent, untainted assets seized and essentially put away from the defendant's effort to use the property to obtain counsel of his choice. But the Fourth Circuit recently, in this year, in United States versus Chamberlain, after the decision of the Supreme Court in Lewis, believed that it could apply the same kind of statutory construction that all the other circuits had applied to find that you could not restrain pretrial substitute assets. Now, this gets to be an important issue when talking about attorney's fees and retainer agreements and the structuring of attorney's fees to satisfy your individual bar association rules, because you can't become too complacent about assets which can't be seized before trial. Because if those assets have not already been taken as attorney's fees, by the time that your client is convicted, the government has the authority to seize those assets, those substitute assets, which takes them away from being used for attorney's fees. Okay. We've got a circumstance where we have a client who has come to us, and the client has had his property restrained, property which he contends is not tainted by any kind of criminal activity. And he wants you to go into court and tell the judge that the government has overreached and has used the processes of the court to restrain property that is innocent, untainted, and available to be used for attorney's fees. The thing about Lewis is that it was very much tied to the Sixth Amendment and the fundamental importance that the Sixth Amendment plays in our criminal justice system. So you're not just automatically entitled to go to court and say you want to have a hearing on the government's restraint of certain assets and you want to use this money for any purpose. You have to be able to go into court and essentially establish your indigence. You have to file a motion with the court where you explain that unless this property has been released, your client will have to get court-appointed counsel because he will not or she will not have the resources to hire counsel. At the point that you do that, the government has to answer your claim of indigence and your claim that the assets that have been restrained are untainted. Now, it's unclear who has the burden of proof in these kinds of hearings. It appears that what the defendant has to do is make a prima facie case that the tainted property, that the allegedly tainted property, is really untainted. And at that point, once a prima facie case has been made, the government has to show by preponderance of the evidence that it had probable cause to seize this property or to otherwise restrain the property. Now, this brings up another issue having to do with the Fifth Amendment. What is the effect of having to shoulder the burden of proving one's indigence in the face of the government's contention that the defendant has no property that is not tainted and has no right to use his tainted property to hire counsel. You may be in a situation where, in order to establish your client's indigence, you may have to present evidence which would incriminate your client. So you have a tension between the Sixth Amendment right to counsel and the Fifth Amendment rights against self-incrimination. And the way the courts have dealt with that is in two ways. One, the courts have held that this information can be provided to the court ex parte and in camera, and that the court can rely upon the information without disclosing it to the government. This is also the procedure used in CJA panel cases, where the question of what detail has to be disclosed to the government in order to justify the payment of legal fees. The second way that the courts have dealt with this problem is to direct that the information be disclosed to the government, but order that the government not be entitled to rely upon or to use this information in its case in chief. So these are the two ways the courts have handled the burden that is on you to establish that your client is indigent. There's another interesting twist in the jurisprudence having to do with the Sixth Amendment, and that is the denial of the right to counsel of one's choice has been held by the Supreme Court to be a structural error. So there need be no harmless error analysis applied to a case where the defendant has been denied his right to counsel of choice. But how is that going to be raised? Presumably, you had made an effort at the beginning of the case to try to convince the court that certain property was not tainted, and the court refused to order the government to return your property so that it could be used to pay for counsel. What this is a ticking time bomb in the government's case. Court-appointed counsel should be made aware that the process that's been used to establish that the property in question was tainted was in error, and that at some point, possibly when the case is being concluded and the defendant is being subject to a sentencing proceeding, at that point, counsel may be able to determine that the property which the government contended was tainted is not tainted, in which case that property could have been used to pay for counsel. And in that situation, you have put the defendant in the position of having an automatic reversal of his case if you can establish that the property in question was not tainted. I now want to go through a hypothetical case where you have a client who has been accused of drug trafficking and money laundering, has his property and his family's property restrained by the government pretrial. So the defendant comes to you, or rather you go to see the defendant who is on pretrial detention. And the defendant has this indictment which lists as its last section a forfeiture count where the government seeks to forfeit the defendant's Mercedes, his wife's Lexus, a safety deposit box with $2 million in it, and his sports fisherman, which is his prized possession. The defendant comes to you and says, "What will you charge me to represent me in this matter?" And you say to the defendant, "It'll cost you X dollars." And you can pick any number out of a hat because you don't know. You know that the defendant had substantial assets at one point and now has virtually no assets. And you know that this is probably going to be a more complicated case than it initially appears to be at the beginning of representation. So what do? You start looking for assets. The first thing that happens is the wife makes an appointment, comes down to your office, and says, "I have a house that we purchased prior to the earliest date in the indictment, and that house is now worth $300,000. There's a mortgage on it of $150,000. But I can sell this house and give you the proceeds from the sale of the house for part of your fee." And you say, "Great." You go ahead and make whatever arrangements are necessary. You may get a deed and you may get a mortgage that you place on the property, whatever makes you comfortable. But then the wife makes an effort to sell the house. The government gets wind of the wife's activities, and they say, "Whoa, we believe that a portion of the mortgage payments on the house were paid by the defendant's unlawful activities. So you have to take X amount of dollars out of the proceeds from the sale of the house to satisfy the government that the money coming from the sale of the house is untainted." But then the government places a notice of lis pendens on the property, stating that the property may be subject to forfeiture post-conviction, and the government has an interest in this property. Well, the effect of a lis pendens is to effectively prevent anyone from being able to sell that property, because no one is going to want to buy a piece of property knowing that the government may come in and argue that this property is tainted and the buyers were not purchasers without knowledge because they were on notice as a result of the lis pendens. A couple of circuits have held that there is no entitlement to a hearing on a lis pendens because it's not a sufficient restraint on the property to satisfy the Fifth Amendment. Now, this is absolute nonsense. And not every circuit follows this. The 11th Circuit does. But after Lewis, you should be able to go in to any circuit that allows a lis pendens to restrain property and argue that the Sixth Amendment prevents that from happening. You quote a fee of $200,000, which is not a particularly high or unusual fee given the complexity of the kind of case that you see in the indictment. And the defendant says, okay, I can pay you from cash that I have in a safety deposit box. Now, if you want, you can take that cash and file the appropriate tax form, Form 8300, but it's not worth it. And it's not worth it because the government will easily be able to come in and argue that any cash of any significant amount are the proceeds of unlawful conduct. And what you've done is you've essentially wasted your time and got the client to believe that he has hired counsel and that you are his counsel and that you will be able to represent him throughout the trial or negotiations. Then you'd look for other sources of income. And the brother has an insurance policy. And the brother wants to borrow against the insurance policy in order to pay part of your fees. You determine that the insurance policy was originally taken out prior to the time of the indictment, but the brother who works for the client has been receiving regular payments for work that he does in the client's nursery. In this case, I would recommend that to the extent money is borrowed from an insurance policy, it's only borrowed from that portion that was available as of the date of the indictment. Now you have the uncle who comes in, and he has $100,000. And he wants to give you this $100,000 to pay for part of your fee. You say, great, write me a check. Guy says, wait a minute, I have this money in cash. Oh, you've got that problem again. So you explain to the uncle that you will have to file a Form 8300 if he pays you your fee in cash. And the uncle says, can't do it. I never paid any taxes on this money. So you say, thank you very much. It was nice finally meeting you, but I can't take that money either. Now let's talk about Form 8300s. You may find yourself in a situation where you have to take some amount of cash. It may well be that your client is able to afford most of your fee by writing you a personal check, or has family that can pay most of your fee that is generated from their businesses, which have absolutely nothing to do with your client. But the fee that your client has to pay exceeds those amounts, and your client says, I've got this much in cash, and I obtained this money from doing XYZ work. If the amount of cash is over $10,000, so that means it's $10,001 or greater, or 10,001 penny. It's got to be over $10,000. You are required to fill out a Form 8300, which is a tax form, and which specifies a whole bunch of information about the person paying your fee, identifying information about this person, who the fee is being paid, on whose behalf the fee is being paid, identification of the person who is the beneficiary of the fee, details concerning the cash transaction itself, from the types of monetary instruments that are used to pay your fees, the amount of $100 bills are tendered. These are all requirements of filing a Form 8300. The one thing I don't think you can do any longer is refuse to disclose the identity of the person who is paying the money for your services. You can attempt to do so, but you may well end up in front of a grand jury being asked specifically who hired you in order to represent your client. And it may well be that it was your client himself who paid that cash, and even though he gave you an explanation for where that cash came from, nevertheless, you do not want that cash to become part of the government's case. So you may attempt to protect that information by asserting an attorney-client privilege and a Fifth Amendment privilege in refusing to disclose the identity of the payor. Well, a couple other details about Form 8300. You have 15 days from the date of the transaction to file this form. The form is filed with the IRS. 15 days. A copy has to be given to the payor, and you have to keep a copy of the form for 5 years. Now, a lot of what I've been talking about with the Form 8300 is for you to protect yourself from either a grand jury subpoena or an inquiry from your state bar association or a potential indictment alleging that somehow you were involved in laundering your client's money. But I would recommend, water, now I see it. I would recommend that all of you obtain a copy of John Wesley Hall's Professional Responsibility in Criminal Defense Practice. That book covers a lot of the issues which we've talked about today, and particular details in terms of avoiding the minefields of the Form 8300. Okay. Let's talk about your retainer agreement. You should always have a retainer agreement. You should always have a retainer agreement when you're representing any client, but particularly when you're representing a client where the government has accused the client of committing a drug offense. The retainer agreement should specify that you are charging a flat fee for your services. And to justify seeking a flat fee for your services on the grounds that you can't withdraw from representation in federal court simply because your client has not paid their entire fee. Now, unless you're in a jurisdiction which allows you to withdraw for a failure to pay fees, you need to establish as early as possible that the money that you receive from your client is earned when tendered. You don't want to be in a situation where at the end of the case there's $20,000 remaining in your checking account. You haven't taken that money for fees. Now you can structure your fee agreement in such a way that if your representation ends after the filing of the motion to dismiss, or at a certain point when you're discharged, if for some reason you would be discharged without having done any substantial work, you can put in your retainer agreement that X amount of dollars will be refunded. But try to make it very clear that the fee that you have quoted is the fee that the client is expected to pay up front and completely. And the reality is that in many cases, what you get up front is all you're going to get. I've certainly been in a situation where I have quoted a fee, taken a third of it, and has never seen the rest of the fee show up, but have been obligated to represent the client nevertheless. You do that enough times and you face bankruptcy. So in your retainer agreements, you have to protect yourself as well as protecting the client. Another thing to have in your retainer agreements is a line that says that your representation is limited to, let's say limited to plea negotiations and sentencing, or limited to the motion to suppress and trial and sentencing. You don't want to be in a situation where you have taken a substantial fee, which can happen in the 11th Circuit, where you take a substantial fee and the Court of Appeals takes the position that you got paid enough for the trial and the appeal. There's a practical problem with all of this. And the practical problem is that your client is indicted, your client is pretrial detained, you have been asked to seek to get the court to change its mind about the pretrial detention, let's say take an appeal from the magistrate's ruling, and to begin to vigorously defend your client's interests. But you haven't gotten paid. And you haven't gotten paid anything because the government has restrained all of the assets, and you have no way of going forward on behalf of this client because you have received nothing and have no expectation that you will necessarily receive any further funds because of the actions that have been taken by the government and by the court. What can you do? First of all, depending upon your jurisdiction, you can file a notice of limited appearance and explain in your notice of limited appearance that you are in the case as a courtesy to Mr. So-and-so, but that you cannot file a permanent appearance until the subject of attorney's fees is litigated. And you agree to stay on the case long enough for you to be able to litigate the question of the restraint on assets. If the court doesn't let you do that, you might as well let the court appoint counsel to represent the defendant, because you simply cannot afford to get involved in a case where the amount of work that you are expected to do greatly exceeds the resources that you have been given in order to do this work. Another thing that you can do is you can have your client simply tell the court that he has the assets, or he believes that he has the assets to hire counsel, private counsel, but needs so much more time to be able to get those assets together. And use that time to see what you can do with uncovering assets belonging to other members of the family or friends who are willing to help defray the cost of representation. You can always go back into a case. If you have developed a strategy with your client where your client understands that despite his desire that you represent him, the whole issue of attorney's fees has to be dealt with first, and it's dealt with by appointed counsel, you can always come in at that point and take over the case. That's a far safer way of proceeding, even though in some instances you will have your client decide that he's perfectly happy with the public defender or with court-appointed counsel. That's the risk that you take. But when you compare it to the other risks of getting involved in a case where there are no assets to pay for your fees, it's a risk worth taking. That's all I've got.